So the 60 days are up in the Miller v. Bonta California assault weapons ban case. The parties have filed all the requested briefs, and now we wait anxiously to see what Judge Benitez is going to do in this case. So let's talk about this. But real quick before we jump into this video, if you agree that California's ban on so-called assault weapons needs to be found unconstitutional, go ahead and hit the like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and at a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what is currently going on in the battle for our rights to keep and bear arms. As I mentioned in the intro, in this video we're going to be discussing how Judge Benitez now has complete control of the Miller v. Bonta California assault weapons ban case and how he now gets to decide the fate of this case. You may recall that Judge Benitez issued an order requiring both of the parties in this case to file supplemental briefs in response to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruin. He gave both of those parties 45 days to file their initial briefs, their supplemental briefs, and then 15 days to file responsive briefs. Well, the full 60 days have run, and now this case is in the hands of Judge Benitez, and he gets to decide what happens from here. The Miller case was originally heard in the Southern District of California before Judge Roger T. Benitez, or Saint Benitez as he's become known in the state of California. In the original review of the case, Judge Benitez found that this case was an average case about average guns used in average ways for average purposes. In reaching his decision, Judge Benitez used a standard review that was just reaffirmed by the Supreme Court. He looked at the text of the Second Amendment and the history surrounding our nation to determine that the state of California's ban on these types of firearms is indeed unconstitutional. After he struck down the California assault weapons ban, the state of California obviously did not like that, so they decided to appeal that decision up to the Ninth Circuit. Now, the Ninth Circuit decided that they did not want to deal with this case. They didn't want to have to review it in light of Bruin, so they remanded this case back down to Judge Benitez. Once this case was back in the hands of Judge Benitez, he held a hearing and set the Miller v. Bonta case to be resolved in 60 days. He set the schedule for both of the parties to file their supplemental briefs in 45 days, and then gave each side 15 days to file a response. California also requested that Judge Benitez push this case out until next March, but ultimately Judge Benitez decided that he was going to deny that request, and so the clock was running for 60 days. And now that time has officially run out. Both of the parties have filed their responsive briefs, and now all of this question, all of these issues is in the hands of Judge Benitez, and now California gun owners are waiting anxiously to see what Judge Benitez ultimately decides to do. Now, I want to point out some of the interesting arguments that the state of California made in their responsive briefs, because this will really go to what Judge Benitez ultimately decides to do. First, the state of California argues that the text of the Second Amendment does not protect the accessories which are regulated under this law. This is because in California's eyes, the accessories are not bearable arms and that they are not in common use for self-defense. Here, California is trying to avoid the Bruin history and tradition analysis by arguing that the text of the Second Amendment does not protect these items, and therefore they don't have to justify their ban with history or tradition. California argues that Section 30515 regulates the use of certain accessories with certain types of firearms, without prohibiting the acquisition or possession of the underlying firearms themselves. Those accessories are not bearable arms, warranting Second Amendment protection, nor are they necessary, like ammunition, to operate any firearm as designed. They go on to state that by legislative design, Penal Code Section 30515 restricts only certain uses of certain firearms, accessories, or parts which are not themselves bearable arms subject to Second Amendment protection. Just as silencers is not a protected arm, the accessories regulated under Section 30515 are not subject to the Second Amendment's protection. So first, the state of California is trying to draw a distinction between accessories and a firearm, or a bearable arm. They are essentially arguing since an accessory is not a firearm, then it's not protected by the Second Amendment, it's not protected by the text, and therefore they don't need to justify their ban with any history or tradition. But the state of California doesn't stop there in their arguments. They then tried to argue that the accessories which are banned under this law are not in common use for self-defense. The state of California tries to argue that common ownership of a firearm is not sufficient enough that these types of firearms in these configurations are indeed protected. Rather, the weapon must be suitable for use in self-defense and be commonly used for that purpose. So they're trying to draw a distinction between common ownership and common use for self-defense. Then the state of California finally gets to the part of their argument where they actually try to justify their ban on so-called assault weapons with historical evidence dating back to 1791. And they try once again to point to historical restrictions on dangerous or unusual weapons. Now, we've talked about this type of argument before in other cases and other videos. The actual language that should be used is dangerous and unusual, not dangerous or unusual. But once again, California likes to try and change the language to actually help them in their analysis and in their arguments. California in this section argues that the ubiquity of state and local restrictions on certain enumerated weapons deemed to be especially dangerous at the time of those restrictions, including Bowie knives, clubs, and pistols, demonstrate that California retains the power to restrict certain types of firearms equipped with certain military-grade accessories. So that's another thing they talk about in their brief. They're trying to claim that these accessories that they are banning are military grade, which we all know that's not true at all. So once again, California tries to characterize the use of a piece of plastic on a rifle as something military grade and so dangerous and unusual that they have the power to therefore regulate it. And then after all of this in the history section, they then try to walk out some of their old arguments, which now are 100% irrelevant, but they are still trying to use these as some sort of justification for the ban that they put in place. They argue that their ban is also consistent with more recent regulations, that some jurisdictions, some other states have bans on so-called assault weapons, and therefore their ban is consistent with those, and it's also consistent with the 1994 federal ban. Again, none of these are relevant historical evidence or support for what the state of California is doing here. The Bruin test said that it's only relevant history dating back to 1791. Now, it's unknown right now what Judge Benitez will actually do. He can decide right here and now if he wants to resolve this case, and he can strike down this law once again. If he does that, he will write another opinion. How long that will take, I don't know. From prior actions and how fast he's been moving in this case, I would suspect that it would be likely sometimes mid next month, maybe. He's shown that he wants to move fast on these cases, so I wouldn't suspect that he would take very long to write that opinion. He might even have a lot of it already written. So again, we don't know how long it's going to take him to actually decide this case. And one of the things that's always an option as well in this case is he can decide that maybe he wants to do some further proceedings in this case if he's not convinced by all the briefs that have been submitted to him yet. But my indication is that he will likely probably resolve this right here and now without setting further trials or hearings or anything, because all he really needs is the supplemental briefs and the responsive briefs that were already submitted to him. So that is where the Miller v. Bonta California assault weapons ban case currently stands. This case is now back in the hands of Judge Benitez, and he can issue a new ruling or set this case for further proceedings. But my best guess, again, like I said, is that he's going to rule in this case and likely find that this ban on so-called assault weapons is once again unconstitutional. So if I get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer best of my ability. You can ask me questions like someone recently asked me more of a festive question about what my favorite Halloween candy is. My favorite Halloween candy really is like Skittles. Those are kind of, I like the sweet stuff. I'm not a huge chocolate person, but let me know down below what your favorite candy is. And I hope you all have a good Halloween, enjoy your time with your family and just kind of have fun and get away a little bit. That's kind of what I'm going to try to do as well. So if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.